And thank you, everyone, for joining us for Litigation Basics episode number 5, Enforcement, Post-Judgment Proceedings and Collections. My name is Stephen Reingold, and I will be your moderator today. This webinar is part of the Financial Poise webinar series, Litigation Basics. Slide 6 summarizes this episode, and Slide 7 provides a summary of the series. Now, speaking of the slides, we will not step through the slide deck in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. But keep the slide deck handy, though, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. Our panelists today are Timothy Anzenberger of Adams and Reese, Scott Bernstein of the law offices of Scott H. Bernstein, Jeffrey Leon of Karen, and again, my name is Stephen Reingold, and I'm from Saul Ewing. Now, we appreciate that you're not spending your time and money to attend this webinar to hear about us. You can read more about us on slides 30 through 33. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to www.financialpoise.com or send an email to info@financialpoise.com with the word subscribe in the subject line. This webinar is being sponsored by the National Law Review. We thank you for your sponsorship. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we'll do our best to get you an answer. Okay, with that, let's get started. So the subject of today's discussion is the enforcement of money judgments, and the focus is on when a defendant or a judgment debtor has not paid a judgment willingly. So how can the plaintiff or the judgment creditor collect? So Tim, first question to you. And that is, just broadly speaking, when should a judgment creditor or a plaintiff start thinking about executing on a judgment or about issues concerning collectibility?
Thank you, Stephen. So typically, in an ideal world, I've been thinking about executing on a judgment even before I file a lawsuit or a collection action. I want to be able to advise my clients what we can expect when we get that judgment. Are the defendant's judgment proof? Are we going to be throwing good money after bad after a long litigation? I kind of want an idea of what assets are going to be out there so that when we get the judgment, we can act quickly to avoid a judgment debtor absconding with assets, transferring assets, or dissipating them. I also want to know that because if we need to take any provisional remedies, if your state law allows for it, such as attachment, to preserve those assets until we get our judgment. Now, if you haven't thought that far enough ahead, you want to be thinking about executing your judgment as soon as you get it, because I think for us practitioners, we encounter debtors that abscond with assets, transfer assets, dissipate them all the time, and it's just sort of part of how this practice goes. But you want to be thinking about it before you file suit, and if you haven't done that, as soon as you get the judgment, you want to be thinking about it immediately.
Right. And, one of the things that we often tell our audience is, every state is going to be slightly different in how you approach things. I want to just pick up on a thread that Tim mentioned, which is, provisional remedies. Different states, allow for different provisional remedies. Check your local rules and local practice. For example, in Massachusetts, it is not uncommon in state court to get a prejudgment attachment, often ex parte, if you believe one of the situations Tim has described might arise. So it is something I think Tim wisely said, start thinking about it on day one or before you even file the litigation. So Scott, let's throw it over to you. So, we talk about when to start thinking about collectibility. When should a judgment creditor start proceedings or taking steps to enforce a judgment? Kind of dovetails off of the comments we just had.
Well, normally in my cases when we're getting close to entry of judgment or we've submitted a proposed form of judgment for entry, I actually reach out to the client because they're usually a good source of of information, especially if they've had an ongoing business relationship that gave rise to the debt. Often clients will have a sense of where the soon-to-be debtor slash well soon-to-be judgment debtor is banking. They may have copies of checks if they've received ACH payments or wire transfers. They may have the remittance information. Similarly, it's very common in a commercial situation for a customer to fill out a credit application at the beginning of the relationship where they have to give a banking reference or other references. So that's I would start there as a source of information. And in terms of when to start collecting the judgment, some states, such as Connecticut, for example, they have an automatic 30-day stay of enforcement of the judgment, with the stay of enforcement actually triggered from the date that you serve a certified copy of the notice of judgment through certified mail. So that's something to think about too, is whether there's an automatic stay on the enforcement of the judgment in place. Other states, such as New York, you're required the service of the notice of entry of judgment just triggers an appeal period. It doesn't, there's actually no stay in enforcement of the judgment. You know, there may be, if you're dealing with individuals, it may be wise to give them notice of what their exemptions are. So you can later say that you've given notice of the exemptions before levying on a bank account or otherwise complying with state law. But essentially, it's a race among the creditors. It's a race once you have the judgment to see who can collect first. I often see situations where, especially in the trade situation, where a debtor is juggling or stretching their accounts payable, and they may have 2 or 3 similarly situated vendors who are all filing suits around the same time and headed toward judgment after having supplied a substantially similar product. So a lot can be said for not sitting on the judgment after seeing what the state laws require in terms of a waiting period, if any.
So Jeff, let's throw it over to you. So one of the biggest challenges in executing on a judgment, of course, is locating assets of a judgment debtor. How do you advise your clients? What do you advise your clients to do to identify and locate a judgment debtor's assets? You're on mute. There you go.
Before I answer that, I want to follow up on something that Tim said, because I think it's very important when you're advising a client. If effort in after obtaining a judgment to actually execute on it, you have to weigh into the litigation calculus whether it's going to be worth the effort, the expense, the money. So if you're taking the case on a contingency, you have to weigh how much collateral post-judgment litigation you'll need in order to collect to get your fee. If your client's paying fee for service, you know, sometimes they can spend as much in legal fees after the judgment as they do to secure the judgment, even more, to be honest, if you have to go, you know, into a bunch of different states and even sometimes other countries to get a hold of assets. So it's very important. And, you know, there's a few ways to go about identifying where assets are. One is discovery. You can, a lot of times through discovery, figure out where the assets are. You also can hire private investigators and private investigator firms. You know, the biggest is Kroll. You know, they're basically a gigantic company, but there are lots of ways to find assets of individuals and companies. You know, and with companies, sometimes you have to disentangle, you know, corporate, you know, flow charts, essentially, you know, with companies owning various LLCs and sub LLCs, and figuring out where the money is that you're after and whether it's moving around. So you have to have some awareness of these things, and you know, try to use the discovery process to try to build the information so that you can go out and, as Scott said, you want to take immediate action, because the longer you wait, the more opportunity the judgment debtor has to kind of shuffle the deck, trying to move money around. And sometimes, as Tim mentioned, you can get prejudgment attachments in states. Other times you can at least get the form of a freeze put in place. You can't collect on the money, but a court in certain jurisdictions can enter an order preventing the judgment debtor from using or moving the funds or assets that you want to make sure are preserved. And of course, if somebody files a notice of appeal and they put up a bond, then you can't move to collect on the judgment. But on the other hand, the bond secures your judgment. So everything that we're talking about is proceeding under the assumption that no appellate bond is been put forward.
Right. And one of the things that Jeff mentioned is discovery and aid of execution. So check your state rules on that. One practice pointer I like to share with people is, if you are conducting discovery and aid of execution and you want to identify assets that might be subject to execution, if you use the form of the schedules of assets and liabilities that is available on the federal court's websites that companies use when they file bankruptcy, it's a really nice, robust list of all different kinds of assets. You can just use that in your post-judgment discovery, so you don't have to wonder, what do I ask about? It's a really nice laundry list of things to follow. So take a look for that if you're in the fortunate position of taking discovery and aid of execution. So Tim, let's throw it back to you. So one of the types of assets that can often be sought to satisfy a judgment is a judgment debtor's income. How do you go about pursuing income or other assets of a judgment debtor?
So generally, if we're talking about income, the most common, and this again depends on what state you're living in, but for me, my home state of Mississippi and many others, wage garnishment is sort of the general one that you go to first. And what that does is it allows you to get either a writ, they call it in some states, or an order in others, issued from the court to the judgment debtor's employer, which then becomes a lien on their income stream. And then the employer begins paying you, the judgment creditor, as that income is paid out to the judgment debtor. And these are often ideal if you actually have a judgment debtor that has a paying job, which is not always the case, but if it is, it's a great way to go ahead and get an income stream coming to you as a judgment creditor on a regular basis. And if they get terminated, if they leave their job and they find new employment, you can issue another writ or another order. So that's a great way to pursue income. Now, there are many states where you can't get a garnishment. So I practice in Mississippi and North Carolina. In Mississippi, we can get wage garnishments. In North Carolina, we cannot. In North Carolina, you're limited to garnishments if it's child support or taxes or those sorts of things. So you always want to know what state court remedies you have. If your judgment debtor receives income from a business, if they're in a partnership, an LLC, an LP, or a business entity like that, you can obtain charging orders in most states, which allow you to attach the judgment debtor's financial interest in that business entity, not the managerial interest. You can't take over their LLC and start, running the business, but you are entitled to their financial interest. So if distributions are being made, you can collect those with a charge order. After that, there's also garnishments that you can issue out to, at least in states like Mississippi, just to bank accounts or to any other person or entity that owes money to your judgment debtor. You can issue a writ of garnishment to that bank account, to that third party, and they have to, when they receive it, it acts as a lien as of the date of service, and in Mississippi for another 30 days. and they have to pay over whatever they owe the judgment debtor to you instead. Very common in Mississippi to go after or to get a writ of garnishment on both the employer and then whatever bank accounts you might know about, or even bank accounts you might not know if they've got an account there, but you issue the writ anyways and see what turns up after that. And then for other assets, of course, execution sales or sheriff sales, as we call them in Mississippi, where you can actually have the local law enforcement, Mississippi, the sheriff's office, go out and execute on personal property or even real property. And those are generally the first avenues I'm going to pursue if the state that I'm practicing allows it.
Right. And what do you do when you run into situations? Let's talk about real property, because this is very state specific. You have a judgment debtor who's an individual who owns a property, let's say with tenants by the entireties with a spouse. What are you looking for in terms of your remedy there? Can you force a sale and a disposition of the asset, or are you stuck waiting?
So definitely state dependent. In Mississippi, we're going to be stuck waiting in a situation like that. But you don't want to let that stop you from making sure that you're perfected. So in Mississippi, what we do is we're going to file our judgment in the chancery court of the county where the property is located. And you want to do that as quick as possible because you want to make sure that you get your perfected judgment in place so that if there is an eventual sale of that real property, you might get any excess proceeds. And you want to do it quickly because, first in time, first in right. You want to be first in line, particularly if you're going after a judgment debtor. You're often not the only person with a judgment or that's going to obtain a judgment. So just go ahead, perfect, make sure you've got your lien, make sure you've got priority over anyone else that's going to come after you. And if there's a sale, you might actually see something at the end of the day.
Yeah, and it's similar in Massachusetts. You send your writ of execution to the sheriff or recording in the county registry, and you do what's called levy and suspend. They record the judgment, so it's a lien on the title, but they suspend execution because they can't force a sale of the property. So another practice tip, everybody, make sure you understand the rules in your jurisdiction because they could differ greatly in terms of how you get to collect on real estate when you have more than one owner. All right, Scott, let's move back to you. So we're talking about different kinds of assets that a judgment creditor can pursue. Are there any assets a judgment creditor cannot pursue to satisfy a judgment?
I mean, generally, each state has exemptions of what you can pursue. In New York, if a bank account has $3,000 or less in it, you can't get the first three for an individual or non-entity judgment debtor. You can't execute on that whatever amount that's less than $3,000. In Pennsylvania, there's a list. It's like a family Bible, wedding ring, clothing, and some other miscellaneous items that you can't execute on.
Right. Also, under federal law, there are certain retirement assets. If you're talking again about an individual, there's certain retirement assets that are exempt from creditors as well. So, if you're in your discovery date of execution, you learn that your judgment debtor has a retirement account. You need to understand what kind of account it is before you send your sheriff out. So, all right. So, Jeff, let's move back to you. So, there are lots of different methods we use once we identify potentially recoverable assets. What are some different means that you've used on behalf of a judgment creditor client to enforce your judgment? And let's break them down into sort of, involuntary by the judgment debtor and sometimes voluntary.
Well, look, your goal, of course, is to collect the judgment. And sometimes if you have a recalcitrant judgment debtor, what you want to do is make yourself as much of a nuisance to them that if they have the means to satisfy the judgment, they'll do it to avoid, all the trouble that you're making for them. So, you pretty quickly as you can, want to force them to participate in post-judgment discovery. And that, again, so much of this is so jurisdiction specific, but sometimes you can force them to sit for a deposition. They have to list things they own. You send out subpoenas. You ask the judge for whatever relief you can get in terms of freezing assets or freezing dissipation. They may freeze the bank account, where they can only access a certain amount per month for basic living expenses, but they can't do anything, beyond that. If it's an individual, you can start it, if you're able to in a given state, putting dings on credit reports. The liens, even if you can't force a sale, can become a real problem because a lot of terms of mortgages require you to keep your property free of competing liens. And so while you can't force a sale, the mortgage holder actually may be able to force a sale if the presence of your lien puts the mortgage holder into default. The other thing, sometimes you have to go outside your jurisdiction, and that may require you to get counsel someplace else to chase down assets. It's a lot easier in federal court, to find stuff in other states. Well, not find stuff, to go after stuff in other states. When you're in state court, say in Illinois, where I am, and I need to go after assets in Florida, I'm going to need a Florida lawyer who knows what they're doing, to comply with all the vagaries of Florida law to get at those particular assets. Which is why, I just want to keep going back to this. I mean, we're going to talk about this for an hour with lots of detail of things that you can do. Very little of this is simple paperwork. Some of it is, but it just costs money to go after the money. And that's why before you file a lawsuit, you have to be sure you kind of know where things are. You kind of know the solvency of the entity or individual that you're suing. And if you think they may be insolvent, you kind of have to decide, whether you have some basic non-economic reason unrelated to how much you can actually recover, in filing the lawsuit. Because you can find yourself doing this for 3 or 4 years, to be perfectly honest. And it can be a very onerous process.
Right. And you don't spend $1 million to collect $500,000. So, it's always a business calculus with the clients that the more information you have up front, the easier it is to make that decision when you start the litigation. I was sort of half joking before about collecting a judgment voluntarily. Have you had situations where you've had a recalcitrant defendant, you've gone all the way to trial, you've gotten your judgment, or you've gotten a judgment on summary judgment, and then you start discussing settlement, voluntary payment of a judgment to avoid all of the things we're talking about in terms of identifying and executing on assets?
Of course. And, the more our assessment is that they can run us around in circles for a long time, the more willing you are to compromise on a number. Some defendants, especially individual defendants, can be pretty successful in rendering themselves judgment proof. Nobody's truly judgment proof, unless you move you and all your assets to like Bermuda or something. But what I would call effective judgment proof, right? Where it's such a difficult task that it's not worth the effort. And you can also get there by starting, the post-judgment process. And, the person, kind of, in the famous words of Roberto Duran, says, no mas, no mas, in that famous fight. Just basically says, okay, let's stop this. Let's discuss a compromise. There's a time value of money, certainly, in taking less money now as opposed to more later. There's also a risk factor that you're spending money chasing assets that you may not be able to get a hold of, or may ultimately not be, worth the value you think that they may have, because they may be dissipated. And of course, you have to spend money to get the money, and you can avoid doing that. So there are lots of reasons to consider, compromising. Now, on the other hand, you have certain clients who, want to pursue everything to the end of the earth out of, venality or punishment, or just to make a point. And if that's the case, well, then you are the lucky recipient if you're getting paid by the hour of two litigations in one, essentially. Because you'll be paid soup to nuts for all that.
So Tim, let's move back to you now. We touched on this a little, but I want to go a little deeper. So, one of the best sources of assets to recover for a judgment, of course, is assets in the hands of a third party. Now, you mentioned charging orders. Let's dig a little deeper, into what a judgment creditor can do if a third party has an interest in the property. Let me restate that. If a third party is holding assets of a debtor, judgment debtor, or to my point about the real estate before, if a third party, a non-judgment debtor, has an interest in that property as well. So kind of a two-part question there. So what do you do when it's complicated like that?
Well, if we're talking about garnishments, if a third party owes your judgment debtor a debt or any money or anything like that, in states that allow just traditional garnishments, you can have a court issue a writ to that third party, which directs them to pay you as opposed to the judgment debtor. And that's one of the most common ways of executing a judgment in some states like Mississippi, for example. And then on the screen, the charging order, that's another one where if your judgment debtor is a member of an LLC, you can't execute on their managerial interest in that LLC. You can't take over the company. You can't start running it. You don't have access to their salary or their commissions or anything like that. But you can get a charging order which directs the LLC to pay the distributions to your judgment debtor to you instead. So that's another way you can go about that. They're common in some instances, but most of the time I run into judgment debtors who that their LLC was the borrower, and they are the guarantor. So most of the time, the LLC itself is completely defunct, and there's no assets to get there. But if you're dealing with a lot of times doctors or medical professionals who might have gone out on a limb, that can be a great way to recover in those instances.
Right. And you mentioned guarantors. Let's touch on that just for a second. It's a little outside of the scope of our pre-prepared outline that we all worked on. But, oftentimes when you have a debt owed to one of your clients, you have an individual or an entity that has guaranteed that debt. And so, have you had situations, Tim, where you've been able to pursue a guarantor as an additional source of recovery?
Very often. If it's like a small business where the LLC was the principal borrower and the guarantors are the actual individuals running the show, a lot of times the client doesn't even want to go after the borrower, the LLC, because it's essentially defunct and it's not going to get paid. They might put that LLC in a Chapter 7 bankruptcy and you're never going to see anything out of it again. But it's the guarantors, the actual individuals that are running the show, that they've got skin in the game and they've got stuff to lose. So if you set aside the LLC for a minute and go directly after the guarantors who realize, oh, wow, I signed that personal guarantee, 5 years ago. I didn't realize that I was going to be on the hook for this personally. That can often bring people to the table to settle or to pay. And it might take you getting the judgment and setting a judgment debtor's exam and sort of making things real for that guarantor to bring them to the table. But that's very common. That happens routinely when you're dealing with small businesses.
Right, and larger. And one of the things we find in these webinars is, war stories often help illustrate a point. I have a situation now. I represent an entity that is a borrower, or excuse me, a lender to a borrower in New York City. There's an $87.5 million loan on a hotel property. The loan came due last week, and we're negotiating an extension while the borrower tries to sell the property. But the borrower and its principals seem to have forgotten that we have a guarantee by one of the principals. And so every time the borrower starts to push back, we pull out the guarantee. Said, we don't really have to have this conversation because this party over here is directly on the hook for this $87.5 million. So how are we going to do this? We're going to do the hard way. We're going to do the fun way. And it changes the dynamic very quickly. The other thing to look out for if you're dealing with a guarantor is in different states, read your guarantee because there's a difference between a guarantee of payment and a guarantee of collection. And sometimes you have to go through the process Tim outlined where you have to go all the way to judgment against the principal obligor. And then when you're unable to collect against the principal obligor, then you have to look to the guarantor and not before. That's a judgment of collection. Judgment of a guarantee of collection. Guarantee of payment is, that's a live obligation right now as soon as there's a default. So read your guarantee carefully and know how it works. Okay, Scott, we touched on this a moment ago when Jeff mentioned being in different jurisdictions, but there are specific rules when you have a judgment against a judgment debtor in federal court. How do you execute and enforce a judgment entered by a federal court as opposed to by a state court?
Generally, if I have a judgment in federal court, and I'm looking to do some sort of garnishment or execution beyond on a bank account, as a practical matter, I get a certified copy of the judgment, and I transfer it to a state court. Usually in federal court, even though you can get court orders to some extent exempting you from using the U.S. Marshals. In federal court, you ask the U.S. Marshals to perform service of your garnishments or your executions or your attempts at seizing assets, and it's a more expensive, I find, more lengthy process. And depending on what jurisdiction you're in, the federal marshals, they may or may not have a lot of experience with it.
Yeah.
So as a practical matter, I transfer judgments from federal court where I get certified copies of the judgments in federal courts, and I record them in state court, and then I start the judgment enforcement process there under a state court docket number. And I usually work with a county sheriff's office where they have a dedicated civil process unit, which will have people who spend their entire day serving garnishments or executing on real estate and who are more familiar with the practice and the procedure and may even move the process substantially quicker. In terms of discovery and native execution, though, if we're seeking to request the production of documents or interrogatories or to take a deposition, that I'm more comfortable doing in federal court because federal courts deal with discovery disputes all the time, and they deal with contempt proceedings and how to enforce an order. And you're really not dealing with the actual sending of somebody to collect something. I think that touches on something too, is when you don't have a guarantor and you're dealing with smaller companies, often the individuals who are the principals of the judgment debtor, they say that they have no skin in the game. They didn't give you a guarantee. They're going to start another LLC. They've already started one. I still pursue discovery and native execution against the defunct judgment debtor because ultimately it's individuals, it's the principals of the defunct company that the court holds responsible for answering the discovery demands. And if they don't answer the discovery demands, you can start seeking court orders holding the non-judgment debtor individuals who otherwise don't have direct liability in contempt of court or getting daily fines against them. And that goes to what Jeff was saying, is that sometimes you have to put people through the paces and force them to do work in order to reach a voluntary payment plan after you've secured the judgment. And on occasion, I've gone as far as you have a judgment debtor who's not obeying a court order providing for discovery and native execution. You get an order to compel their answers. You get an order holding them in contempt of court, giving them a daily fine. And then ultimately, a lot of states do allow you to request a civil action warrant for arrest. The warrant for arrest, it's not because someone failed to pay a debt or they refuse to make payment. It's just that they're not complying with an order providing them to answer interrogatories in aid of execution or produce financial documents of some kind. And while it may seem like an extreme measure, judgment debtors or even the owners of non-judgment debtors, when faced with a request for their arrest for failure to comply with discovery, they do wake up and they do often start talking. Even though that's almost toward the end of the judgment collection process after you've exhausted other options.
So Jeff, back to you. You touched on this earlier. Let's dig a little deeper. So you have a judgment creditor client. You have identified assets in a different jurisdiction. You mentioned briefly, what you would do if it were a state court judgment. Let's talk about that a little more. And on the screen, I've got the Uniform Enforcement of Foreign Judgments Act, which most of the states in the U.S., 40-something states have adopted. But also, you have a judgment in federal court. To my mind, that's a heck of a lot easier. What's the process for domesticating a judgment in another state, in state court, and in federal court?
I mean, well, if you have your judgment in federal court
Right.
already, that's one thing. I mean, it's pretty hard to domesticate a state court judgment in federal court unless you end up with some diversity of the parties that didn't exist.
No, I'm assuming we already have a federal court judgment.
Yeah. So I mean, you just have to follow the procedures in the act. They're all specified. And while it is a uniform act, right, as is the case with all uniform acts, it's not actually uniform as to how a state chooses to actually codify it. So you have to know the procedures in a given state in order to go ahead and domesticate the judgment. It's so much of this is you got to pick up, I'll be old fashioned since I am 60 and say, pick up the statute book, although nobody actually picks up the statute book. You got to read the statute. You got to apply it. And this stuff is really technical and you can get really tripped up on all of these things that we're talking about if you don't do exactly what the statute says you have to do. Courts will not enforce liens, will not enter orders of attachment or garnishment if you don't do the precise series of steps that you're required to do. But you have to domesticate your judgment, say in Florida, from say Wisconsin, if you want to go after assets in Florida. And one of the most famous things is that Florida has the homestead exemption, right? You can't go after someone's house. So, that's like just a clear example of knowing if the only asset you want to go after in Florida is someone's primary residence, you're not going to be able to. So that would be a waste. That would be a waste of time. I do want to talk a little more about this LLC thing because I think it's very important.
Sure.
Steve, you were talking about a situation where you're making loans, and of course, these days very few lenders are going to make a loan without a guarantee. But there are many other sorts of real estate projects or development projects, for example, energy development projects, where every project is done through an LLC created specifically for the project. That's just how it's done. And from a post-judgment perspective, and even during discovery itself, because one thing I want to make clear, we talked a lot about post-judgment discovery, but you can get a lot of this type of discovery during the case itself. It's okay to do it. You have to know what the law is for what's called piercing the corporate veil in the state in which the LLC is incorporated, and try to ask the questions in discovery, to try to figure out, how fast and loose was the operation of the LLC. A lot of times, by the time you sue the LLC, it merely exists as a piece of paper. It has no employees, it has no bank account, because the project is over. And they owe, say you're a contractor and they owe you money. So, and rarely are contractors able to get, say, the managing partner's personal guarantee, that they're going to be paid at the end of the day. So you're going to have to pursue, collateral litigation over piercing the corporate veil, in order to try to go after the principles of, of the LLC. You're going to have to, just show that they were, improperly, looting the LLC of assets, and then just setting up a new LLC with a new name down the street that does exactly the same thing. And gee, it has exactly the same assets as the other LLC. So a good deal of post-judgment litigation, it involves, the difficulty of trying to pop the bubble of protection that, the LLCs or other forms of incorporation, provide to the owners of those businesses. And so, that's a whole different body of law. It's not technically judgment enforcement. It is, every bit as important, when you're dealing with corporate defendants.
Right. And to pick up on the thread there, one of the things you look for in your post-judgment discovery, you're looking for transfers, away from the judgment debtor, whether it's to the principals or to a related entity. And most states have adopted some version of the Uniform Fraudulent Transfer Act, where a known or unknown creditor can bring a claim against the recipient of an asset of the judgment debtor, if the elements of the statute are met, in order to bring that money back in, or that asset back in, to satisfy a judgment. So to Jeff's point, you want to be asking the right questions and following the money trail outside of the judgment debtor. One final point.
Steve, if I could,
Yeah.
sorry, you just raised something which I don't think we've discussed, and it's not on our outline, but
Mm.
it's important. There's another uniform act called the Uniform Fraudulent Conveyance Act. And if there is a big transfer of money, you can sue the recipient, and say that it was a fraudulent conveyance, that they received, in order to evade judgment or starve the corporation of assets. And you can actually sue them to get it back. And again, a lot of what we're talking about with these proceedings, judgment in the sense that you're doing it in the same court with the same case number, is the case you obtained it. We're talking about situations where you have to file additional lawsuits, right, to go after the recipient of what you maintain as a fraudulent conveyance, or to go after the principals of the LLC directly, filing lawsuits against them in their name, claiming that, the LLC was a sham. And the requirements for piercing the corporate veil are present. So, there's such a wide panoply of directions that you're going to go, depending on the form, individual, corporation, what type of corporation, where they are, where they're, and then, issues like, what happened to the money, and trying to trace all that down.
Right. And just one final point before we move on the foreign judgment question that we started with. So, obviously take a look at state law when you go to use Jeff's example, from Wisconsin to Florida. But if you have a judgment in federal court and you want to execute on assets in another jurisdiction, you can also register that judgment, assuming it's a final judgment and the appeal period is run. You can register that judgment in the U.S. District Court in another district simply by filing a form, and that's also available on the U.S. Court's website. Okay, so let's move back now to Tim. So we're talking about all the wonderful things we do on behalf of clients to collect money, but sometimes we have judgment debtors do things to try to hinder our efforts. What are the kinds of things a judgment debtor that you've seen can do to hinder or delay the ability to collect? We talked a little bit about transfers to related entities and the like. What is it you've seen?
So what I see most often is just they do not participate in your efforts. Very often, if it's a collection suit, you're probably getting a default judgment, which if you're in state court, that can take a while. So you've already got a lawsuit where they're not participating. It's going to take a while to get your judgment. And if you're in a situation where you don't have a personal financial statement or you don't know what assets they have at the time and you've got to take post-judgment discovery, they can ignore you. They can ignore your process server. And you've got to spend significant time and money trying to locate them where they are so you can serve them with the written discovery. In Mississippi, we have the ability to take judgment debtors examinations, which is a deposition of their assets. But if you can't find the person, you're going to have to go through significant loopholes with the court trying to get contempt hearings and then having them send out the sheriff to find them. And if the sheriff doesn't find them, what do? You're basically sitting around for a couple months until the deputy can find the person, bring them before the judge. Typically, they tell the judge they want a lawyer, and in some cases, if this is the first time the judgment debtors appeared before the judge, they might give them that second chance. So it's just like what Jeff was saying, that sometimes you find yourself spending a lot more money after you've got the judgment just trying to discover the assets than you ever did actually getting the judgment in the first place. That's what I see most often. Then, of course, probably another really common one is they file for bankruptcy. That happens all the time. And so then you've gotten your judgment, you're ready to collect. They file bankruptcy, which starts a whole brand new proceeding from the beginning that you're going to have to participate in. And if you've got your judgment, but it wasn't enrolled in the land records, you might be sitting there as an unsecured creditor at that point at the very end of the line. And then, of course, what Jeff was just talking about, transferring assets to others, where you might discover the transfers, but you've got to file a brand new lawsuit against the transferees, get your judgment against them, and then collect from them. And then it's sort of the never-ending the never-ending task. But hopefully your client's got personal financial statements at before you file suit. You've thought about looking for assets before you filed suit, so you might already know what's out there. You might have done your investigation in discovery during the process, so you know what you're looking for ahead of time. But I mean, if they're not going to cooperate, they're not going to show up. They're going to evade service. They're going to evade the sheriff. It can really hold you back.
Yeah. And one of the biggest assets that we often like to look to is, of course, insurance policies. So your automatic disclosures in federal court, you have to identify if you're a defendant, if there are any insurance policies that might be available to satisfy a judgment. Most state courts, civil rules have a similar automatic disclosure. If your state does not have that, ask for it in discovery, not in your post-judgment discovery, but ask for it in discovery. We talked earlier about how soon you start that process. Tim said day one or before day one. In your initial request for production, ask for insurance policies. Ask for communications with the insurer, because you might have a source of payment there that you hadn't thought of. Scott, let's go back to you. One of the things that Tim mentioned, I want to pick up on. What happens? You've gotten your judgment. You've won the case for your client, and your judgment debtor files bankruptcy. Are you out of luck? What do you do?
I usually file an appearance in the bankruptcy case, and I monitor it. A lot of bankruptcy, usually if it's a Chapter 7 bankruptcy proceeding, there's a bankruptcy trustee who's appointed to investigate the debtor's assets and liabilities and incomes and expenses. And if there are assets, the court or at the bankruptcy trustee's request will set a bar date or a deadline to file proofs of claim, so all creditors can share in the pro rata distribution. Similarly, if you do have a lien, your judgment lien has attached to real estate, and it's going to be sold in bankruptcy, the bankruptcy court process should follow the order of priority under state law, and the sale proceeds, to the extent they exceed other lien holders, should be used to satisfy your judgment lien. And quite frankly, if you've had difficulty getting discovery from the judgment debtor, and you think they have done transfers, or there's been some sort of financial maneuvering, like they have to show up at to the bankruptcy Section 341 meetings of creditors. They have to make disclosures of assets and liabilities. You can get information and try to help educate the trustee to sources of recovery that could benefit all creditors. And truth be told, sometimes the debtors, they don't comply with the bankruptcy rules, and they don't finish the bankruptcy proceedings. Or they try to get out of it because there are assets that they've hidden, or they don't want to be administered as part of the bankruptcy proceeding. And on a rare instance, after the bankruptcy case is dismissed because of something the debtor has done, I just pick up where I left off and start the judgment enforcement process all over again. It's just a delay or a speed bump.
Right.
And the stay itself, I was just going to say,
Yeah.
doesn't affect your ability to, if a company's filed for bankruptcy and the guarantors haven't, you can still pursue the guarantors. Similarly, if there's sureties or insurance companies, they're not protected by the bankruptcy filing either. That's
Right. I mean,
And so
to the extent the debtor has an interest in the policy proceeds, you probably better practice is to go to the bankruptcy court and seek relief from the automatic stay, so you can continue to pursue the claim against the surety. Another thing you can do is, if you haven't liquidated your judgment to a sum certain, or you didn't finish the process before the bankruptcy filing, sometimes you can get relief from the automatic stay to finish your state court process, get your judgment but not execute on it, take that judgment back to the bankruptcy court so that your claim is now a liquidated sum. So, if you find yourself faced with a situation where you have a judgment debtor or a defendant that has filed bankruptcy, make sure that you have somebody, in your circle who knows bankruptcy. If it's not somebody in your firm, somebody in your circle, because the rules are very different once a company files bankruptcy, whether it's an 11 or a 7. All right, we're closing in on the hour. Jeff, I have one more question for you, and then everybody, I want to kind of get your final thoughts as to what you think new practitioners, new litigators ought to know about enforcement proceedings. But Jeff, first to you. You made the point earlier, and I think it bears repeating and expanding upon, about following the rules closely when you're seeking to execute on a judgment. What are the consequences of improperly executing on a judgment? What if you didn't read the rule right, or the sheriff messed up, or you got the wrong entity? What are the consequences?
It depends on the state, of course,
Mm.
but you could have some exposure. If you improperly impair somebody's asset and it does their business harm, you could get sued. You could also get sanctioned, right? As a lawyer, if if it didn't meet, the basic good faith diligence requirement, you can get sanctioned. Probably have to pay the attorney's fees of the party whose assets were improperly liened or garnished or whatever. I mean, you got to be really careful. Look, this is the kind of thing where certain big law firms have practice groups that's literally all they do. I had a case. We got a big judgment against the nation of Iraq, and we weren't gonna even try to figure that one out. Go to a big law firm, they have the investigators, they find the assets, they figure out a strategy. Ultimately, the judgment got reversed on appeal, so we never actually got the opportunity to go ahead and do that. But the bottom line is that this is an area that there are people where it's all they do, if it's big enough, right? For a lot of solo practitioners, you just end up having to learn this stuff because, too often you're going after entities or people that are, on the knife's edge of solvency, and you're just forced to learn it by doing it. Which, frankly, that's how all of us have learned this. You don't really study this much in law school in very much detail. we've all learned it the hard way, by having to go through it.
Right. Or having to respond to it.
Right.
I had one, years ago, I learned a new phrase. It's not new anymore to me, but it was at the time, slander of title. I had an opposing party file a lien on some real estate. Turned out not to be my client's real estate. They made a mistake and they liened up somebody's property who wasn't involved in the litigation. That's slander of title in some states. And that could expose that party to damages and the attorneys to sanctions, to Jeff's point. So, be very, very careful when you're executing on your judgment. Okay, we've got 5 minutes left. I want to give each of you, a chance to share with our audience, our new practitioners, what are the most important things that you think they ought to know or to be aware of as they go down this path of post-judgment enforcement proceedings. So, Tim, let's start with you.
So I think the most important thing to do is, especially if you're new to it, is read through all the statutes to figure out what state court remedies are actually available to you. And you might discover some that you didn't think were there that can be incredibly useful in your specific case. And also, when you're doing this kind of work, you got to be creative. Your state might allow you to execute on causes of action. Send the sheriff out to execute on a cause of action that you can then, you can be the one that files suit on that. You can become an investigator. You can do your own investigations to find out where these folks are, what other states they might have assets in. And it takes a little bit more than, the normal paperwork. You can be the investigator and be creative in what's out there. That's what can make this kind of, this part of the process really interesting. It's not totally academic, but it can actually start to be fun and, with that element of creativity involved.
And if your firm has a Westlaw account, there are asset locator, categories in Westlaw. You can ask your library to just run an asset search on your judgment debtor. And, all of a sudden you found the boat and the car and the house, and, it's a good start.
Facebook,
okay.
Social media as well.
Social media as well. That's right. I've forgotten, in the digital age, that's a good way to find assets. Scott, you, final thoughts? What are the things that you would like our new practitioners to know or be aware of?
I mean, there's a lot of avenues that you can go down for trying to collect on a judgment, but I mean, it really is, though, it's digestible because it's a step-by-step process where you don't do everything at once. And similarly, the goal of so many of these collection matters is to get to the judgment debtor to a voluntary payment agreement where your client, the creditor, forbears from executing on the judgment in exchange for a schedule of payments. And there it's a matter of persistence. You don't know assuming the judgment debtor has the ability to make payments in some meaningful amount and is not truly judgment proof, you don't know what step is going to, or what action is actually going to lead them to want to enter into the judgment forbearance agreement and to make regular payments. And there it's just a question of persistence. And I would encourage practitioners to just be persistent.
That's very, very good advice. Jeff, final word from you. What are the things that are most important for our new practitioner audience members?
I just want to reinforce, something I said at the very beginning, which is know what your client is getting into before they get into it. You can save them and yourself a lot of angst and surprise if you, explore the solvency or ability to pay of the person that you're suing, considered in relation to the amount of money you're seeking, and tell the client, that they're not going to be able to just write a check for this, not ever. And that means we're going to have to go after a bunch of illiquid assets, or force the liquidation of illiquid assets. And that's going to cost, X in addition. And sometimes in the middle of the case, the financial status of the defendant changes. They start losing money. One thing we didn't talk about is something called running a Dun and Bradstreet report, which shows, how a business is paying its bills, how far they are behind in paying bills. I mean, there's a lot of ways you can kind of figure out whether you may be suing a dry hole. And you don't want to do that. You do your client a service when you advise them that they may be doing that, and the risks that they run in pursuing the litigation in the face of that possibility.
These are all excellent practice pointers. I hope our audience members take note of them. We are now up against the hour, so with my thanks to our panelists, this does conclude our webinar. To our audience members, thank you for joining an entertaining and educational production of Financial Poise. Thank you, everyone, and goodbye.